Hello, everyone, and welcome to our webinar on how to do a Regulation A+ offering. So we're going to really explain to you what is this Regulation A+ and how to get it done. We'll talk about the costs, we'll talk about the timing, we'll compare it to the IPO process, we'll compare it to other exempted transactions, and we'll just describe what we see in the market. And then you're welcome to ask us questions throughout the presentation or after the presentation, and then we'll be happy to share with you our PowerPoint slides. If you would like to have a copy after the presentation, just let us know. Okay, so let us present ourselves, introduce ourselves. My name is Arina Shulga, and I'm a partner at Mitchell, Silverberg & Knapp. It's a law firm with offices in Los Angeles, New York, Washington, D.C., and it's a full-service firm. So we provide advice, not just corporate and securities, but also litigation, trust, and estates, employment, tax, and all other matters. So, today, a member of our corporate and securities department, Blake Barron, is here to join me. Hi, Blake. How are you?
Hi there. I'm great. Hi, everyone.
Okay. So Blake's practice focuses on mostly like registered securities offerings, including Regulation A+, initial public offerings, and ongoing reporting obligation. My practice focuses more on representing startup companies in their private placement transactions when they're raising capital, as well as ongoing corporate and securities law-related advice. So together today, we're here to tell you all we know about Regulation A+. Okay, Blake, shall we start?
Sounds great.
Okay, so I'm going to share our presentation, and then I'm going to disable my video just for during the presentation, so all you guys can focus on the slides, and then we'll come back for like a Q&A. Okay, so I hope everyone can see the slides now, and welcome again. So I'm going to start with talking just about some history of Regulation A+. So Regulation A+, the first thing that I think really important to understand is that Regulation A or A+ is not the same process as an initial public offering, okay? So you're not registering the securities. You are qualifying the securities for an exemption from registration with the Securities and Exchange Commission. So Reg A+ is not a mini IPO, like as people, think about it, because it's actually an exemption from registration with the Securities and Exchange Commission. But this exemption actually follows pretty much the same path as an IPO. And we'll explain to you exactly why and how that's happening. Okay, so we've always had this Regulation A, right? But people didn't really use it. And according to the previous Regulation A, state securities laws required registration in every individual state where securities were sold. So you can imagine that a Regulation A offering often got like very expensive and very complicated. Like I read recently that there is an example of how back in 1980, when Massachusetts state deemed the offering of Apple computer stock to be too risky and did not allow the Massachusetts citizens to participate in the Reg A offering. So back then, it was all about state regulation and registration in every individual state. So that's why Reg A was not a popular choice. So as part of the Jobs Act, Title 4 of the Jobs Act, the SEC, Securities and Exchange Commission, got the task to modernize Regulation A. And so they came up with rules that became effective on June 19, 2015, and they introduced the new Reg. And that's Reg A, and that's why we're calling it Regulation A+. So it's like the old, but it's really the new Regulation A+. That's now totally changed, right? So before it was limited to 5 million, the investment amount. Now it's 20 or 50 million, depending on the tier, and we'll talk about that in a bit. And if before it was all subject to individual state registration, well, now it's only tier 1 that needs to comply with individual state securities laws, right? Tier 2 is preempted, and we'll talk about that more. So when Regulation A+ first came about, there was a lot of excitement about it. And the SEC, and here I'm quoting the SEC member, and others were really excited about using Regulation A+ as a way to raise capital, for startups as well as for more mature companies. So let's see what really happened, going forward. Did it really work? Okay, so now let's look in review. From 2015 through 2018, only, and I'm saying only, right, approximately 1.5 billion has been raised in 157 Regulation A+ offerings. So you would think it's a lot, but actually it's not that much comparing to $3.4 trillion that had been raised privately, relying on other exemptions from registration. So most often companies didn't use investment banks, right, to place their securities, and just sold their securities directly to investors. And the shares did not trade publicly. Actually, out of 157 companies that conducted Reg A+ offerings, only 11 used Regulation A+ to list on NASDAQ or New York Stock Exchange American, right? And all but one are now trading below their IPO price. So as you can see, I guess Regulation A+ has not been as widely used as was once anticipated. Well, let's see why. But first, let's understand the two-tier approach, right? So the Reg A+ offering is divided into 2 tiers, and each tier has like its own requirements, right? So companies need to decide whether they're going to do a tier 1 offering or a tier 2 offering. But I have to mention, even if you're raising, like, let's say only 10 million, you don't have to do tier 1. You can voluntarily do tier 2. Right, so just because you're raising less than 20 million does not really box you into, using tier 1. Okay, so tier 1, you can raise up to 20 million in any 12-month period, and tier 2, up to 50 million in any 12-month period. But then I have a question. How do you determine this 20 million, 50 million? Is it based on what? Is it based on price per share? How do you determine that? Blake, what do you think?
So, I mean, for any company that's thinking about undertaking a Regulation A, there's obviously going to be a discussion between management, potentially, some market participants, whether that's investors or investment banks, in connection with what those parties believe would be the right value for the company's securities. So there's typically a discussion that goes on back and forth. Now, if the company's just selling directly to investors, a lot of times a company will utilize sort of a price per share from a prior offer. Right, if they've raised money and maybe it was 2 months before, you can do a calculation based on that. Maybe there's a premium to it based on the fact that maybe there have been some developments since the last offering that you can attribute and increase your offering price to. Now, once you've determined what the exact offering price should be, in order to determine whether or not you're going to exceed the $20 million for tier one or potentially, go right up to the 50 million, you are going to aggregate the total amount of securities by the securities offering price. Most of the time, we will see shares of common stock that will be offered in a Regulation A offering. And in those situations, it's pretty cut and dry, right? If you're selling 1 million shares at $1 a share, you're going to have an aggregate offering price of $1. If you are including selling stockholders, which here, if you see the tiers, we have certain information in parentheticals that talk about secondary sales. You can qualify those secondary sales by, let's say, management or maybe current stockholders. You can qualify those in your Regulation A offering, and they could sell to the public. In those situations, you would take those shares, multiply them by your share price, and you would add that to the overall aggregate offering price. The one thing to keep in mind, which is different when talking about other exemptions, is for Regulation A, you do have that ability to qualify the resale of existing stockholders' securities. In a Regulation D offering, which is another private exemption, that ability is not available, right? That is just an exemption for a company to issue to investors. So a lot of times a company may like the flexibility that they have to, allow, family and friends that came in an earlier round, or maybe, just existing stockholders the opportunity to have some liquidity with the stock. The one thing that's really important is that when you qualify the resales, it has to be at a fixed price, which is different than what would typically occur in a traditional IPO. At an IPO, a selling stockholder could resell into the market at the prevailing market price. In a Regulation A offering, they have to sell at the offering price in the Reg A, because otherwise there is the possibility that you would exceed the maximum offering price set forth in whatever tier you may be subject to. So that's one thing to keep in mind. Now, the last point about determining the offering price is to the extent that you're going to offer some sort of convertible security. Let's say you're going to offer warrants to purchase common stock. The shares underlying those warrants would have to be taken into, the value of those shares would have to be taken into account in order to determine whether or not you were selling less than the maximum offering amount allowed by Regulation A. So in those situations, you would take the exercise price of the warrants, multiply it by the amount of shares underlying those warrants, and that would be added to the aggregate offering price. Now, obviously, all these calculations can, be a little technical, and you'd want to consult with an attorney to make sure that, the shares that you're making to investors in the market, any shares or other securities you may be qualifying for resale, and then any other sort of underlying securities in the offering meet the requirements of Regulation A.
So I think it gets pretty complicated, right? If you're not if you're offering anything other than common stock.
That's correct.
It gets really complicated in terms of calculating the price and making sure you don't exceed the upper limit. But I think what's really cool here, and the main point, is that I think Reg A Plus is the only exemption that allows you to include sales by affiliates. Right. So if you want to do, include the possibility of existing shareholders to sell some of their shares, then it's either you do Reg A Plus or you have to do an IPO. That's seriously, that's all I'm seeing. Because as you mentioned, Blake, none of the other exemptions really allow for resales. They're all primary sale exemptions. So this is a good thing about Reg A Plus, definitely. although it may make that calculation a little bit more complicated, but that's fine. That's why you have, the attorneys who've done it before kind of guide you through that. Okay, so moving on, now let's talk about who is actually eligible to use Reg A Plus to conduct an offering.
Yeah, so before I get into the eligibility, I do just want to remind our attendees that, you are welcome to submit questions via the Q&A button on the right side of your screen. So, if you're joining on your mobile device, it's going to be on the top of the screen, and you can submit those questions at any point during this webinar, and we'll be happy to answer any questions you may have. So obviously, you're going to want to know whether or not you are eligible to use Regulation A. So the SEC's rules provide that any U.S. or Canadian issuer is eligible to utilize this exemption, provided that they don't fall into certain categories. Those categories are going to be an investment company or business development company, and those are entities that are formed primarily to invest in the securities of other issuers. In addition to that, if you are a blank check company, which is typically defined as a company formed solely for the purpose of entering into a business combination, those types of companies are also not eligible to utilize Regulation A. There's also a prohibition on an issuer of fractional undivided interests and oil, gas, or other mineral rights, and then issuers that may be delinquent in ongoing reporting obligations under Regulation A. So as you can see also just from that, if you do one Reg A offering, let's say in a year, you can do multiple Reg A offerings, right? It's just you have to make sure that you don't exceed the aggregate offering price depending on which tier you're subject to. Now, with all of that said, there is one important thing to note here about eligibility, and that's the company and certain covered persons cannot be what is known as a bad actor. Now, a bad actor, you may be familiar with this language because it is applicable in a Regulation D offering as well. A bad actor would be, a company or a person or other entity that has been convicted of a felony or misdemeanor relating to the securities laws. Perhaps there is some sort of regulatory bar against the issuer or that person. So it's really, it's exactly what it sounds like, right? It's some company or person that is acting in some sort of illegal or criminal way that would prevent a company from completing a Regulation A offering. So, that's going to apply to the issuer, to the management of the issuer, which would be executive officers or the board of directors, as well as any type of promoter or participant in the solicitation of investments that's going to be compensated, as well as 20% beneficial owners of the issuer. Now, typically in our practice, we will prepare questionnaires right at the outset of, discussing the potential offering, and we'll circulate these to the issuer, to potential participants, just to have an understanding as to whether or not there are any potential bad actor events that would either need to be disclosed or that would prevent an offering from occurring. That way we can address anything on the front end to avoid any issues once an offering is underway. And this sort of diligence process is something that the SEC requires an issuer to undertake, right? An issuer can't just turn a blind eye to these requirements. They need to affirmatively take steps to verify that there are no events that could jeopardize the issuer from using Regulation A.
Okay, well, that sounds great. So now let's look at who can invest into a Reg A Plus offering. Who are the investors? And the good news is that it's anyone. So not just accredited investors, but anyone can participate in a Tier 1 offering. Okay, there are no restrictions, there are no limitations. Wonderful. Tier 2, that's the one with the up to 50 million, amount, offering price amount, is subject to a per investor investment limit that only applies to non-accredited investors. unless the securities are then listed on the National Securities Exchange. And that limitation is that those people cannot invest more than 10% of the greater of their annual income or net worth for natural person, right? Okay, the good news is that unlike in a Rule 506C offering, that's a private placement exemption that came out as a result of Title II of the Jobs Act, right? Investors here can self-certify their income or net worth for purposes of the investment limit calculations. So it's not like the issuer can just have a reasonable belief and rely on the self-certification by the investors. So which is good, news for the issuer. But I'm still like really puzzled about the fact that in a tier 2 with the lower amount, 20 million, you can have anyone, but then if it's a tier 2, then non-accredited investors are subject to this investment limit. Why even have that? I'm really not clear how being in a tier 2, which actually requires audited financials, right, would still kind of lead to limiting the investor as to the amount they can invest. Blake, do you have any opinion as to why Tier 2 would place this limitation?
Yeah, it seems sort of strange, right? As to why in Tier 1, you can extend it to anybody, right? Regardless of the size of their actual investment. And we've reviewed a bunch of the SEC sort of comment letters that they received in connection with putting forth these new rules. And a lot of commentators did sort of express the desire to maybe extend this 10% limitation to Tier 1. And really, after review, the SEC said, we understand that that may be helpful, but the SEC is not as concerned with an investor in a Tier 1 due to the lower aggregate offering amount that's permitted, right? So the difference between 50 million in a Tier 2 versus a 20 million in a Tier 1 was apparently sufficient enough for the SEC to get comfortable with not including this 10% limitation in a Tier 1 for non-accredited investors. Now, I sort of think that's a little bit of a strange situation where you could potentially have an offering in the Tier 2 that's less than 20 million. So it does seem a little bit strange, but the SEC apparently felt comfortable enough with moving forward on that basis.
Interesting. Yes, exactly. You can be only raising, let's say, 10 million, but do it as a Tier 2 offering instead of a Tier 1. And then all your investors will be subject to this maximum investment limit.
Right. That's important. It's an important, note to that, just because you're raising less than, let's say, 20 million does not mean that you need to do a Tier 1, right? You can do a Tier 2, and we'll talk, I think, later about really the benefits of potentially doing a Tier 2 versus a Tier 1.
Mm-hmm. Yes, we will. Okay, let's move on. So let's talk about the best thing about Reg A Plus. That's the ability to test the waters, right?
Mm-hmm. That is correct. Yes. So, I mean, the ability to advertise your offering and solicit is something that, generally speaking, is unique for Regulation A. So, we call these types of communications test the waters communications. It is in some ways similar to an IPO, where, an IPO, there's very limited circumstances where you can sort of solicit interest in your offering to the public market. In an IPO, you have to go to certain accredited investors. They're called qualified institutional buyers, right? Here in a Reg A, companies can put out press releases. You can, advertise on your website. So it's really, it allows a lot more flexibility in engaging in the market, sort of figuring out what the market interest is in your offering before you even, go ahead and start selling securities. You can start to figure out what the right price is going to be. So it's just a really helpful tool for companies to go out and figure out if they can actually complete this offering. Now, one thing that's a key here is that anything that you put out, any sort of communication, will have to be transcribed. So let's say you're doing an interview on the radio or TV or on a blog, that would have to be transcribed and then filed as an exhibit to your offering statement that is submitted to the SEC. So the SEC is going to review these materials in connection with their review of the offering statement. Now, those communications will also require a certain legend that just says this is in connection with a Regulation A offering, and you should review our offering statement, which is going to contain certain risks relating to this offering and the company. So you're going to want to talk to an attorney to make sure that the proper legends are included and that you're keeping track of all the communications that are made. Because, from my experience with Regulation A offerings, there's going to be a lot of communications going out. So we've typically said to our clients, hey, let's create an Excel spreadsheet. Let's track when things are issued. Let's, make sure that they're attached as exhibits. And it's been a lot more organized when it comes to then filing those communications with the SEC. Now, the SEC, you would think that they're extremely busy and they may not take a look at all these different press releases, but I can tell you from experience, they certainly review the communications that are put out by companies. There are situations where we've seen a client inadvertently leave off a legend in a press release, and we've actually had the SEC come back and say, hey, I want you to go back. You have to revise that press release and make sure that wherever you distribute it, there's a correction that includes that legend. So they're definitely looking at these communications. There's always the potential for, having some sort of liability connection with it. So you're going to want to make sure that the statements you're making are verified by management. You're going to want attorney review of it, and to make sure that, there's no risk associated with putting out those types of communications.
Well, I think I also want to add that there is just one other exemption from registration that comes to mind that also allows for general solicitation and advertising, and that's Rule 506C of Regulation D, right? So where companies can also reach out and to not just their existing networks, but pretty much to anyone, and tell everyone about their upcoming offering, but those offerings are only limited to accredited investors. So Reg A Plus gives you like a chance, right, to talk about it, advertise and solicit, and actually offer those securities to non-accredited investors. So I think this is a unique feature of this rule that I think is very welcomed by all the issuers. Okay, moving on to the offering statement. Blake, are you covering this or am I? I forgot.
I would love to cover it. Yeah, I mean, it's the offering statement is going to be your disclosure document for your offering. So it's going to really be comprised of three different parts. The first part is sort of this just overview as to, when your company was formed, who your auditor or accountant may be, your lawyer, kind of just gives a high level sort of summary, and that's submitted to the SEC. The second part of your offering statement is going to be what's known as the offering circular. This is exactly what you think of when you talk about, a private placement memorandum or a prospectus in connection with a true IPO. This is really the meat of your disclosure, right? It's going to include risk factors, a description of your business section, the discussion of your financial results and financial condition, may have some additional related party disclosures, as well as your financial statements. Now, it's important to note that for a Tier 1 and a Tier 2, there are different financial statement requirements. So we'll talk about that a little later, but it is just a notable difference between the tiers. Now, the third part of your offering statement is going to be your exhibits. Now, a lot of companies, especially early stage companies, don't necessarily have it sort of depends as to where you are in the stage. You may have material contracts that the company is substantially reliant upon. Those types of agreements will need to be filed with the SEC as part of your offering statement, as well as executive compensation agreements, the governing documents for the company. So there's a whole level of review that will take place to make sure that company has the required disclosure, the required exhibits, and a list sort of the high level points of fundraising that the company's been engaged with in the past. Once the offering statement is ready, it can be submitted to the SEC either on a confidential basis or a public basis. A confidential basis just means that it's not automatically made public. You can undertake a review with the SEC without anyone seeing sort of changes to your drafts up front, and you could always make the decision whether or not you want to move forward with your Regulation A offering, or if you want to potentially not move forward with it, depending on maybe where the market is, how the SEC review is going. We typically recommend that our clients file confidentially first. The SEC typically takes about 30 days maybe to review the offering statement and provide comments, and then it's a back and forth between the company and the SEC. Now, before any sales are made under Regulation A, the SEC has to qualify the offering statement. Now, if anyone here is familiar with an initial public offering, this is very, very similar to the process in order to make a registration statement effective, right? In the IPO context, the SEC will declare a registration statement effective. Here in a Regulation A, the SEC will qualify that offering statement. Once it's qualified, you can go ahead and make sales under that Regulation A offering statement.
Well, to me, it actually sounds that putting together this offering statement is quite a complicated and big undertaking, right? It seems like it's asking for a lot of disclosure, a lot of information about the company and the business section and the risk factors and so on. Blake, in your experience, how long does it take for companies to put together this information?
Yeah, Arina, you're 100% right. This is a lengthy document that's going to take a significant amount of time and resources at the company to put together. Now, depending on the state of the company, it very well can take anywhere from 3 to 6 months to just prepare the offering statement. So, if a company has a really good business plan, maybe they've already had a financing that required a private placement memorandum, a lot of those disclosures can be translated into the disclosure for an offering statement. But it's important to note, a lot of these disclosures are very much the same as would be found in your traditional IPO S1 registration statement. In fact, the SEC allows a Regulation A company to either follow a format that they set forth in what's known as the Form 1A, or they can utilize the disclosure items in Part 1 of Form S1. Most of the time, we'll recommend to our clients that they follow the form for Part 1 of Form S1. So it's going to look very much the same as an S1 registration statement disclosure. And the reason for that primarily is to the extent the company does want to undertake an IPO in the future, a more traditional IPO, let's say on NASDAQ or the New York Stock Exchange, you're going to have those disclosures sort of already prepared and ready to go. The second reason is really because investors are typically familiar with that sort of setup, as well as potentially investment banks. So the market is, traditionally more comfortable with that type of presentation. So we try to make sure that investors receive a disclosure document that they've seen before and that they are comfortable with, in order to make sure that the offering is completed on a timely and successful manner.
Yeah, it sounds like you might as well do an IPO, right? Given how much disclosure you have to prepare, and that it's going to take 3 to 6 months to actually put it together. Incredible. Okay, and I just want to say that, for example, if you're doing a private placement in reliance on another exemption, for example, Rule 506B, right, and you're just selling to accredited investors, you don't even have to provide them with this disclosure, right? It's not required by the rule. So so this is a trade-off. Okay, that's fine. So talking about required disclosures, okay, tier one offerings, that's a good news for them because the financial statements need not be audited. So that's great news. I mean, the company still needs to provide financial statements, but they don't have to be audited. However, for tier two offerings, they have to be audited. And that adds time, adds costs, right, to get the audited financials that I guess the company will just have to include in the cost of overall Regulation A offering. So this is kind of the big difference, right, between the tier one and tier two is the audited financials part. Okay, and now actually moving on to Blue Sky. So Blue Sky laws are state security laws, right? We know that, you know, there are federal securities laws that we're mostly talking about here, but then each state has its own set of securities related laws. And for some reason, I actually don't know why, they are referred to as Blue Sky laws. Blake, do you know why they're called Blue Sky?
No, I don't. We've always just accepted it as it's just a state blue sky law.
Okay, wonderful. So would you like to tell us about the Blue Sky laws as they apply to tier one and tier two offerings?
Sure, sure. So as Arina, as you mentioned, there's this sort of two layers of review. You've got your federal securities laws, which we're talking about when thinking of Form 1A and Regulation A, and you've got your state level. For a tier one, the issuer is going to have to submit their offering statement and qualify that offering statement with the SEC and the state security regulators, depending on the jurisdictions that you're selling in, right? So if you plan to have an offering under tier one in all 50 states, you're going to have to do what's known as a 50-state blue sky survey. You're going to have to determine which states require qualification, and you're going to have to do this sort of second layer of review, response, and qualification with the state regulators. Now, this is different in the tier two, and this was an important change that the SEC made in connection with the amendments in 2015 regarding Reg A. Now, tier two, state registration and qualification, they are preempted by the SEC review. So in a tier two offering, and this is why a lot of issuers will voluntarily submit under tier two, even though it's less than $20 million, the offering size, because you don't have to have that offering qualified in each state you plan to offer securities in. Now, at the beginning, I think when people started doing tier two offerings, they thought, oh, this is going to save us a lot of time and a lot of money, which generally speaking is true. But an issuer needs to know that there may still be filings that'll need to be made with certain states. So, you know, it's typically, we call them just notice filings, and you will submit your offering statement and pay a fee to the state. So it's typically all about the fees. The states want to make sure that they receive some sort of fee in connection with the offering if you're going to sell securities in their jurisdiction. So that is, even though in tier two, the actual qualification and registration of the securities are preempted, you're still going to need to undertake some additional effort to notify those states that you're undertaking a tier two Regulation A offer. So, you know, in the past, our clients, I mean, it depends on the exact state, but it could vary anywhere from $500 for a notice filing all the way up to $1,000. And it really, it's an important factor to consider when determining which states to offer securities in. And the laws are fairly complicated. So again, you're going to want to contact an attorney to walk through which states require notice filings and what the requisite fees would be.
Well, it sounds more and more complicated as we go on. Okay, so now about the ongoing reporting obligation. So for tier one companies, once the offering is done, they have to file this exit form, and that's all, right? They don't have any ongoing reporting obligations. And by reporting obligations, I mean the requirement to make filings with the Securities and Exchange Commission, right? So, but tier two companies, they will be treated similarly to a public company. They have to file annual reports with audited financials, semi-annual reports, and current reports, kind of announcing certain news that are material to the investors, right? But okay, the requirements are a bit less than for a public company that's also has reporting obligations, but they still exist. They still definitely exist for a tier two company, and pretty much the disclosures. I mean, how long do you really have to report? Well, the disclosures can be terminated. The earliest they can be terminated is after one full fiscal year, right, after the Form 1A was qualified. But that's provided that the number of shareholders you have is below 300. So, and the longest is like full 3 fiscal years. But then it's also subject to some minor qualifications and provisos in the rule. So for a tier 2 company, expect to keep on reporting for at least a year, and pay to have your financials audited and all the kind of reports prepared. So that's kind of an ongoing cost that companies need to be aware of. Okay, so now let's talk about liquidity, because I think that's like a really important topic, right? Because people do Reg A Plus not just to qualify their securities, but actually to be able to sell and resell and perhaps create a market in the securities. Well, how easy or how difficult is it, or how realistic is it, Blake?
So it's important to know that, a Regulation A offering, if you buy securities in that offering, those securities are not deemed to be restricted securities. So everybody talks about, oh, they're freely tradable, right? And that's one of the real benefits to Regulation A. But the issue that always arises is, okay, I bought in a Regulation A offering. These shares are freely tradable. And I sell them to somebody in Massachusetts, whether it's a private sale or maybe there's a public market for the securities, right? There is, again, we refer to these blue sky laws, right, with the state. So you qualified your securities with the SEC. Maybe you did a tier 2 or a tier 1 offering, and you did whatever was necessary with the state to qualify the initial issuance of those shares. But now you want to go ahead and resell those securities. Well, unfortunately, you've got to make sure you comply with the blue sky laws. So in order to do that, an issuer will either have what's known as a manual exemption, which is a secondary trading exemption, which be obtained if the issuer is published in a manual such as Mergent, or if perhaps they are quoted on the OTC markets. The OTC markets has a blue sky exemption, and I believe it's in excess of 37 states that you're permitted to sell in. Those are sort of these blanket exceptions that would provide for the resale of Reg A securities. Alternatively, you can talk to an attorney and say, okay, I want to sell to this person in this state. Can I go ahead and do that? And the attorney will work with you to find if there's a specific exemption in connection with your limited sale. One thing that's important is, a lot of issuers think that somehow a public market will be established in connection with the Reg A offering, and that's not necessarily the case, right? If you're talking about, trading securities on a public market, you can go through the process of listing on a national exchange, or a lot of times the requirements to list may be too burdensome for an early stage company. So if you're not eligible to list your securities on a national exchange, a lot of other companies will utilize the OTC markets. And that could be the OTCQX, QB, the pink sheets. There's ways to have your securities quoted through that marketplace. Now there, you would need to have a FINRA registered broker-dealer complete a Form 211, which is under 15C 211 of the Exchange Act, and that will allow for the public quotation of the securities. Now, I've done a substantial amount of work on 15C 211s, working with the FINRA registered broker dealer. I can tell you it is a complicated process. It does take time. It does, again, the management, the FINRA registered broker dealer, and counsel is going to have to, expend a significant amount of resources to respond to FINRA comments. So it's a lengthy process. And honestly, we're finding that less and less broker dealers are going through that process on behalf of issuers just because they're not compensated in connection with it. It's actually a process that the broker-dealer cannot require compensation for. So over time, we're seeing less and less banks involved with that process, and it's becoming a little bit more challenging for issuers to initiate quotations. So it's something for a company to think about. Perhaps it'll allow more investors to resell if you are qualifying. The OTCQB provides for that marketplace, but there's a lot of additional work there that an issuer would have to think about before going down that path.
Yes, and I just want to mention that the purpose of today's presentation is not to talk you out of doing a Reg A Plus, but to just provide a realistic expectation of what is actually involved in conducting a successful Reg A Plus offering that will then later provide some liquidity for the shares. So it's not easy, but it's done. Okay. So, and next, we just want to tell you a story that's been in the news just recently. And this is a story about Longfin Corp, okay, the company that actually conducted a Reg A Plus offering. So it was formed in February 2017. And then already in December 2017, it qualified its Reg A Plus statement and raised $5.7 million. So all within 1 year. Note that pretty much all of the activities of Longfin Corp were actually outside of the United States. But then they listed on NASDAQ and kind of started trading. But in April of 2018, the SEC filed a complaint against the company, alleging illegal sales of securities. So what happened was that apparently right shortly after Longfin began trading on NASDAQ, it announced an acquisition of a cryptocurrency business. Because of that announcement, its stock rose like dramatically, like 13 times, right? And its market capitalization exceeded $3 billion. Well, apparently around that same time, the company's CEO and controlling shareholder caused the company to issue more than 2 million unregistered restricted shares to some of the affiliates. Right, and then they decided to sell those unregistered restricted sales, as part of their general stock that was qualified and listed on NASDAQ, and at those high prices, right? And therefore, they were about to, as a result of that, they were about to pocket like more than 27 million in profits. So obviously, that was stopped. They had to return all these gains. And as a result, NASDAQ halted trading of Longfin shares actually the same day that the SEC filed the complaint. But that's kind of not the end of the story. On June 5th, 2019, so now we're just like 2 months ago, the SEC filed a new complaint against Longfin Corp, and this one alleges fraud. So what happened is that So the complaint alleges that the company actually obtained qualification for a Reg A plus offering by falsely representing in the SEC filings that the company was principally managed and operated in the US, when in fact the company's operations, assets, and management remained offshore. So I think this is one of the things that perhaps the lawyers for the company should have maybe found out as a result of the internal due diligence process that kind of goes on, while you're working on the offering circular. But I guess it didn't work in that case. Also, what happened was that allegedly the company distributed over 400,000 shares to insiders and affiliates just in order to meet the NASDAQ listing criteria without obtaining payment for any of the shares. And then they represented to NASDAQ the number of qualifying shareholders and shares sold in the offering. I mean, Blake, don't you think like we would have noticed that the company is just handing out shares left and right? Because obviously, as a result of due diligence, you have to look at all the shares that have been issued, check the price at which they were issued, and do this exercise, kind of internally. And also, the SEC's complaint alleges that they actually engaged in the accounting fraud, and that they reported more than 66 million in sham revenue, representing nearly 90% of their total 2017 reported revenue. So, not surprisingly, the shares were delisted from NASDAQ, and the company actually shut down its operations as well. So, but this is a story, just a very recent story that's still in the news about a company that conducted a Reg A plus offering, and I think it shed some, light as to some of the activities that may not be going with respect to Reg A plus issuers, and highlights the importance of making everything possible to avoid this type of allegations. Blake, so what happened as a result of this?
Yeah, so after the Longfin saga, NASDAQ proposed additional rules to safeguard investors in a Reg A offering in connection with the listing on their exchange. So what NASDAQ has done, which rules went into effect, I believe it was at the end of July, that now if you are going to conduct a Reg A offering, and in connection with that offering, list your securities on NASDAQ, that operating company has to have operated for at least 2 years before its listing. So as we note here on the slide, to the extent that this rule was applicable back in 2018, it would have actually prevented Longfin from listing on NASDAQ. So, obviously both of the New York Stock Exchange and NASDAQ are, really scrutinizing any type of Reg A listing on the exchange. As we noted earlier in the presentation, there's only been about 11 listings on the exchange. Now, there's a couple different reasons for that. I mean, one is this heightened scrutiny that NASDAQ and the New York Stock Exchange is undertaking. But also, when doing a Reg A, a lot of the reason behind it is so you're subject to less stringent requirements as what we call sort of a full SEC reporting company, right? There's less ongoing reporting requirements, a little bit less disclosure requirements in a Reg A offering statement versus an S1. If you're going to list on NASDAQ or the New York Stock Exchange, they're going to require exactly what they require of a company doing a traditional IPO, right? So Reg A doesn't really seem to help you in connection with the New York Stock Exchange or NASDAQ listing, except maybe in connection with the testing the waters communications, right? Going back to that sort of solicitation process, that gives you additional flexibility. So again, you've got to weigh the pros and cons of the exemption from the traditional IPO process, and then think about what your overall goal is. If you want to just raise capital and provide for potential liquidity, or if you want to see your stock quoted on NASDAQ in connection with your Reg A offering.
Okay, great, thank you. So now, and I guess like we've talked about this before, but this is just to prepare you guys. In terms of average legal fees, they can range from 50,000 to 150,000. Can be more. Like for example, Blockstack that just recently qualified the Reg A Plus offering of like 28 million, right? They did the tier 2 offering. They paid approximately 2 million in legal fees, but they're the first kind of blockchain company that was, issuing or qualifying tokens that are going to be distributed under Reg A Plus. So that was kind of an exciting event that just happened, I believe, in July last month. So in terms of timing, let's say we just mentioned that it takes about 2 to 3 months to prepare the offering circular, right? And then let's say a month for SEC review, and then they can, like maybe a couple of rounds of comments. So overall, we would estimate about 6 to 8 months for the entire Reg A Plus process. I mean, it can be done faster if the issuer has, a lot of the information already available and prepared, so that the lawyers can put together the offering statement, and hopefully the accountants can audit the financials on an expedited basis. So then it can be less time, but I would say counting at least like 6 months would be kind of a reasonable kind of time frame. Okay, so now, Blake.
Yeah, so Arina, I mean, we've gone through a lot of the differences and sometimes similarities between a Reg A and an IPO. Why would a company do a Reg A versus a traditional IPO?
Well, this is a good question, given everything we said, that we just talked about, and saying how difficult and complicated everything is. But I mean, there are definitely some advantages, right, to Reg A Plus. First, Reg A Plus is most likely to be used by kind of younger companies that are maybe less established. So the offering sizes are smaller, right, than in a typical IPO process. So the possibility to test the waters, right, is amazing. And we think that this is one of the best parts of Reg A Plus, most attractive reasons, right, of why you would do a Reg A Plus. Because maybe as a result of testing the waters, you'll actually find out that you don't want to do a Reg A Plus. Forget about an IPO, right? So that's definitely something that companies can do even before they spend too much money on like legal fees and accounting fees, right, and putting together the entire offering. Yes, the SEC review process is shorter. Listen, S1 does not get reviewed by the SEC in 1 month. I can tell you that, and I've done several IPOs myself, so definitely shorter SEC review process, 1 month plus, subsequent rounds. That's nice. You can actually get this thing out pretty quickly. Less onerous financial statement requirements? Well, yes, considering for tier 1 that it doesn't require audited financials. So definitely, more attractive if you use a tier 1. And even for the tier 2, I believe it's like less years that you need to provide the financials for. So that's also good. Typically, an IPO would be done through an underwritten offering. So there would be an underwriter, like an investment bank, right, that would first purchase all the shares and then resell the shares. And that's how IPOs are done. Whereas in a Reg A Plus offering, it's actually many companies, or most companies, do it directly without an involvement by an investment bank. And that allows people to participate, like from the very first kind of offering in the entire offering process, right? And not get shares at like much more inflated prices. A small point to mention is that you actually have to pay the SEC to do the S1 review for the IPO, whereas the qualification of a Reg A plus statement and review is free, so you don't have any SEC filing fees. Lighter ongoing reporting obligations. Yes, for sure. Tier 1 doesn't have any, and Tier 2 can get out of them like in a year, provided they have less than 300 shareholders. Whereas an IPO, the company that has conducted an IPO is more likely to list the shares on an exchange, and that just triggers the ongoing reporting obligations. So it's just like ongoing. There is no end. For a while. What's nice about the Reg A Plus offering, that the company can actually be conducting other offerings simultaneously with the Reg A Plus offering, right? Like, for example, Reg S is an offering to non-US investors. That can be done at the same time, or maybe even a private placement under Reg D, right? That's also a possibility. Whereas it's actually not possible to do this when you're conducting an IPO. You kind of halt all your other offerings and you do the IPO. So it's either that or nothing. Okay, so now that we're all convinced that everybody should just do a Reg A Plus instead, let me ask Blake a question. Why would the company actually want to do an IPO as opposed to a Reg A Plus?
Well, I think, one of the, most common reasons is, everybody sort of understands what initial public offering is going to be. You're going to likely be on a national stock exchange, whether that be NASDAQ or the New York Stock Exchange, which may not necessarily be the case, right, in a Reg A. So, NASDAQ or the New York Stock Exchange will, they're not going to apply this new 2-year requirement for you to have an operating company. But even so, you're more likely to end up listing on a national exchange with a more traditional IPO versus a Reg A offering. Another reason is a lot of the times the disclosure requirements are the same for an offering circular or, versus a traditional S1. So a lot of the disclosures you're doing can easily translate to an S1 prospectus. Additionally, investment banks are more likely to underwrite an S1 versus Reg A, which could be extremely helpful if the company needs to be introduced to investors, right? The investment banks are typically more likely to do an IPO because the offering size may be larger. The investors that they talk with are more comfortable and familiar with the traditional S1 process. So a lot of times they may not necessarily be willing to take liability on in connection with a Regulation A offering. Now, also, if you're going to list on an exchange, there's going to be preemption, right, from state blue sky laws. So that's another nice reason that you won't have to expend a lot of effort in reviewing the state blue sky laws if you know you're going to end up on a national stock exchange in connection with your offering.
Okay, well, that sounds good. I mean, these are definitely good reasons why to do an IPO. I guess both are possible, but then I think there are other options as well, right? So companies can use other exemptions from registration, not just Reg A Plus, right, to conduct an offering of their securities, especially when there are younger companies that are still kind of growing, developing, and are not quite ready to spend $150,000 to do a Reg A Plus. So Rule 504 of Reg D, it's actually not commonly used, even though it's been revised just recently. But even though it allows to offer securities to like non-accredited investors as well, but it's really up to state regulation, right? So every state, you have to qualify the offering or register the offering, whatever exempt offering in every state where you sell the securities. So I actually I don't think we commonly work on Rule 504 offerings at all, and I don't know actually that they're being used that much. But what's really being used is Rule 506B offerings, right? where you offer to accredited investors, and then up to 35 non-accredited but financially sophisticated investors. This one has no cap on investment amount. State regulation is preempted. States can only ask for like a notice of filing and maybe filing fees, and but there is no general solicitation or advertisement that's permitted. So the issuer can only reach out to the existing network and persons with whom they have pre-existing business relationship, right? But I would say that Rule 506B is the exemption that's used for, I would say, most private placement transactions that are going on. I mean, there are more. There is a Rule 506C that was promulgated as a result of the Jobs Act as well, that allows companies now to advertise and solicit their offering openly, right? But then the company has an obligation, actually a burden, to make sure that it sells the securities only to accredited investors. So the company must verify the accredited investor status of the investors. The problem here is that even if there is like one non-accredited investor that somehow gets to purchase those securities, will disqualify the entire offering, right? So it's only accredited investors, and the company's obligation to check that they are in fact accredited. And there are different methods of how to do that. And the last thing I wanted to say, that there is still, regulation crowdfunding out there, right, where anyone can invest as well, although those offerings have to be conducted through a registered portal, and the issuer can raise only up to 1.07 million in such offering, and there are other obligations as well, or limitations that the issuer would have to be aware of. So they're not that easy to conduct, but we see more and more Reg CF offerings around, so which is actually they're typically used by smaller companies as well, and definitely the legal fees are not anywhere near the Reg A plus offering fees. Okay, great. Well, I think this concludes our presentation for today. Here's the slide that has our contact information. If you want a copy of our slides, I will be happy to send them to you. Please email me and I will send you a copy of our slides and be happy to answer any other questions you have. Okay, so now I'm going to end the slideshow and turn on my camera to see if there are any questions.
Yeah, Irina, I see one question here from an attendee, and the question is, if a U.S. issuer is owned by a foreign person and substantial portion of the U.S. issuer's operations is based outside of the U.S., are there any sort of substantial presence or other similar requirements which would require the issuer to move the operations to the U.S.? So as we know, you have to be either a U.S. or a Canadian issuer in order to utilize Regulation A, but sometimes the company...
I don't see you.
Can you see me now?
Okay, hold on. Yes, I see you now. Excellent.
Okay. So, to answer that question, the SEC will, let's say a U.S. issuer, so you have to be formed under the laws of the United States or Canada, so the actual issuer of the securities. Now, you would also need to have your headquarters, so your principal executive office in the U.S. or in Canada. Now, you can, as a U.S. issuer, have operations outside of the U.S. You can still be eligible to utilize Regulation A, but the only caveat is management needs to direct or control operations of the issuer from the United States, right? Because the whole purpose of the Jobs Act was to really create additional jobs in the U.S. So as long as the principal executive office is here in the U.S., you're directing and controlling operations from the U.S., it should not be an issue. Now that's different than what happened in Longfin, right? The operations and management were overseas, and that's where the problem was created. But as long as you're here in the U.S. directing things, you can utilize Regulation A.
Great, thank you. Do we have any other questions?
We've covered most of these questions. There was one additional question I think that we didn't cover, and says, what are the rules for selling securities to international or non-U.S. investors outside of the U.S. through Regulation A+.
Okay, so.
Well, in that situation, you're still going to look to comply with Regulation A, right? For U.S. securities laws purposes, you're going to, still have an offering statement. You're going to qualify that with the SEC. Now, when talking about investors in other jurisdictions, we'd have to work with either attorneys licensed in those jurisdictions or, talk to other specialists that, may be qualified in those countries to make sure that we're satisfying those countries' requirements. Because the SEC takes a little bit more of a backseat approach when talking about investors in other jurisdictions. So we'd have to just make sure that you're complying with those requirements. But from a Reg A standpoint, it's going to be similar.
Okay, excellent. Anything else? Any other questions? Well, you can always email us. And my email is ays@msk.com. And Blake's is bjb@msk.com. And our website, msk.com, just go there and you'll find us, on the website. Feel free to send any additional questions or ask for a copy of the slides. We'll send it to you. And thanks a lot for participating on the webinar, listening. I hope it was useful.
Thanks, everyone.
Okay, thanks, everyone. Bye.
Bye-bye.